Welcome to our Israel-Palestine podcast, a project by graduating high school students from Berlin-Neukölln, home to Germany's largest Palestinian diaspora, and a second home to many young Israelis. Israel and Palestine are painfully present in our district and in our schools. We've spoken with historians, legal scholars, trauma researchers, and educators, some of whom are world-leading experts to better understand this ongoing conflict. Our approach has been multi-perspectival. We don't aim to resolve controversies or contradictions, but to hear different perspectives. Human rights and international law are the foundation of responsible multi-perspectivism. Can we learn to listen and hold conflicting truths at the same time? Find your own answers, or better, questions. Are you ready for the discomfort of learning?
Welcome to a very special episode of our Israel and Palestine podcast. I'm Mert.
And I'm Yusuf, and we're deeply honored to have Michael Sfard today with us. A very warm welcome, Mr. Sfard.
Hi, good to be with you. Thank you for inviting me.
It is our pleasure.
Thank you so much for your time.
Michael Sfard is one of Israel's most prominent human rights lawyers and internationally recognized for his outstanding work in international human rights law, humanitarian law, and Israeli constitutional and administrative law. He is the grandchild of a renowned sociologist and Holocaust survivor, Zygmunt Bauman. His parents have been expelled from Poland for their involvement in the University of Warsaw student uprising against the communist government in 1968.
Marcus Sfard is representing major Israeli and Palestine activists, human rights and peace organizations, several of which he has also represented in the Israel Supreme Court. His office mission emphasizes legal activism, combating occupation, racism, and other forms of discrimination through litigation.
He is the author of several books and a frequent contributor to the Israeli and international press. His last groundbreaking book, The Wall and the Gate, Israel, Palestine, and the Legal Battle for Human Rights, was published in 2018.
To start off, what made you choose this path? Why do you become a human rights lawyer?
Well, first of all, thank you for this introduction. And thank you for, doing all this research about me. Why did I choose that path? First of all, I became a lawyer because of American court drama TV series. I didn't know what it is to be a lawyer, except what I saw on TV. And when I went to the university, to the Hebrew University in Jerusalem to enlist, I actually thought I'll be computer scientist. During the 90s, it was a big thing, computers. Not that it is not now. And then I saw that you need to fill in several options. And I've decided that I want to actually, the first option, eventually I wrote law, thinking that I would do, even back then when I was very young, I already thought that if I'll be a lawyer, I'll represent people in human rights cases. I did not know back then that almost all of my work will be involving litigation on surrounding the Israeli-Palestinian, the Israeli occupation over Palestinians and Israeli domination over Palestinians. But I thought I'll do human rights work already back then. That's what I was very political. When I was a teenager, I went to rallies and I signed petitions, even at school. So doing human rights work was something that I wanted very deeply to do already back then.
Was there a moment early in your career when you realized this isn't just all legal, but also deeply moral and personal?
Yes, in fact, when I started doing my internship after graduating from law school, I joined a very famous Israeli civil rights attorney who was my mentor for the internship period. And that's where for the first time I was acquainted with the issue of Palestinians in the occupied Palestinian territories who have no civil and political rights. I knew about that, of course. I knew about the Israeli occupation, but I was not aware what kind of life they lead and what kind of hardships they face when they have to deal with Israeli authorities and with Israeli settlers, the Israelis who immigrated into the occupied Palestinian territory and basically disinherit many Palestinians from their lands and dominate and oppress them. So that's where I came to intimate acquaintance with that. And gradually I understood that as an Israeli, as a Jew, who would like to lead a life that incorporates the lessons learned from the Second World War, from the Shoah, from the Holocaust, my humanitarian and humanistic worldview. If I want to do all that, I want to live in Israel, this is what I need to do. It's not just a question of profession. It's not only a question of career, but it's a question of being able to live in Israel in order to be there as part of the dominating group, the Jewish group, which is the dominating, the strong one, the one that rules. I need to do human rights work in order to justify my being there. So during my apprenticeship, my internship, and then the first 2 years of my work, it dawned on me. I suddenly realized that my job, my day job, is not just a job, it's a way of life, and it's a moral vocation, it's a moral calling that I need to do in order to keep on living here. Here being in Israel.
I want to start giving a little bit of context. Can you explain to our listeners how our current rule-based world order, ensured by international law, historically evolved?
Well, international law is not new. International law was there in antiquities times. We can see international norms that have been in place, in the Hellenistic period and even in the biblical times. I once researched this and studied this and found interesting norms that were in place between nations, between peoples, even in very ancient times. But modern international law has went through a process of change, and in fact, in 1945, it went through a kind of a revolution. 1945 is a very important year for modern international law. That's the year that the Second World War was over, and that's the year that the United Nations was established. And with the United Nations, the UN Charter, which is a very important document in international law. And what is amazing about that year and about the restart of international law is that humanity, facing 2 world wars and a huge amount of atrocities, with Europe in disarray, with 70 million people killed in this war, and 6 million of them in the Jewish Holocaust genocide. The international community, the human race, has adopted for the first time as a guiding principle for international law the idea of human rights, the idea of humanism. And you can see that in the UN Charter, in different articles of the UN Charter that is scattered. And probably the most important change, development in international law of that year was the incorporation in the UN Charter of a completely new prohibition, one that was never there in international law, the prohibition on the use of force in international relations, with the exception of self-defense. So you and I, although we have many years between us, you're very young, I'm not very young anymore, but we are all creatures of the post-Second World War international rule-based order. For us, it's clear that countries cannot just start a war just because they want, to get the oil field on the other side of the border. That's not legitimate. It's obvious for us. Well, if we would held this meeting, this conversation 100 years ago, before the Second World War, if we would hold it in the end of the 19th century, I would tell you, as an expert in international law, that every state has a lot of tools to pursue its interests, economic tools, political tools, cultural tools, and military tools. Military is one of the ways to get your interests. So the modern international law aspired to take that tool, force, out of the legitimate toolkit that every state has, and to eradicate as much as possible wars. So that is a major change in international law that is very relevant to the issues that we will talk about in the next minutes. When is it allowed to use force, and what kind of force is allowed?
Could you elaborate what are the major institutions of this rule-based order, like the International Court of Justice and the International Criminal Court, and can any of the two actually enforce the jurisdiction?
Well, enforcement, first of all, to the ICJ, the International Court of Justice, and the ICC, the International Criminal Court, we should add, of course, the United Nations. And the United Nations, of course, the ICJ, the International Court of Justice, is the supreme judicial organ of the United Nations organization. An international organization, the United Nations, is extremely important. It has, there are many other institutions and many tribunals and courts, including regional courts like the European Court of Justice and the European Court of Human Rights. Yes, one is part of the EU, and one is part of the Commission of Europe. So, which is a different international organization. We have different systems that apply international law. All kinds of fields of international law. We have a tribunal that is dedicated to the law of the sea, that deals with conflicts that has to do with maritime law. We have human rights committees that adjudicate questions about human rights. For example, the Human Rights Committee of the United Nations, or the Committee about the Rights of the Child, which deals with the convention, the International Convention that deals with the rights of children, and so on and so forth. There are all kinds of institutions. The problem is not with the lack of institutions. We have a lot of institutions, and they are, some of them, extremely professional and extremely independent, and they provide high-quality judgments, rulings, and advisory opinions about the law, about international law. The problem with international rule of law is not the lack of judges. It's the lack of enforcement. Because enforcement, unlike in domestic jurisdictions, let's take, for example, Germany. If a court of law in Germany makes a ruling, then you have the police to enforce it. You have all kinds of other public institutions that have policing powers. They can force a person to pay a fine or to pay a debt that he or she owes to another person. The international law does not have an international police. It does not have an international enforcement mechanism, enforcement agency. What it does have, it has several things. First of all, it has enforcement agents. The agents are the states themselves. The states are supposed to apply international law. If an international criminal court issues an arrest warrant, then all the states that are members in the International Criminal Court are bound to arrest and extradite the person, the subject of the arrest warrant. If they don't do that, then the arrest warrant is meaningless. So the international law is based on the conduct of states as agents of enforcement. I will just add to that another institution that is responsible for enforcement, and that is the UN Security Council. The United Nations has a Security Council. In that council, there are 15 members, all states. 10 of them are temporary, and they change constantly, and 5 are permanent. The 5 permanent members of the Security Council are the powers that won the Second World War. It's the United States, the United Kingdom, Russia, China, and France. And they have a veto power, but for resolutions of the UN Security Council. But the Security Council has the power under international law to take measures, sanctions, economic sanctions, and even to take collective action by force. So that's the one exception to the rule that I discussed before, the prohibition on the use of force. One exception is that a collective action led by the Security Council is permissible even by force. And the Security Council is supposed to be the organ that will enforce international law when it comes to issues of security and peace. So it's a very flawed system, but we have a system. And one last thing, there's also another issue that is very important for the enforcement of international law, and that is shaming. Shaming. No state wants to be blamed that it violates international law. States are sometimes saying the most bizarre things to argue that what they've done is compatible with international law. If you ask Vladimir Putin, his invasion to the Ukraine was an act of self-defense. If you ask Saddam Hussein, well, you can't ask him because he's dead, but if you would ask him back then when he invaded Kuwait, he would say that this is a war of self-defense. Kuwait was intimidated, it was threatening Iraq. So you see that states are trying to be seen as adhering to international law. And shaming is an important, very important part of international law. International civil society has the power, international civil society, by going out to the streets in blaming and shaming states and leaders who commit crimes.
To follow up, could you explain what the Rome Statute is and what does it mean that Israel hasn't signed it?
Well, actually, Israel signed it.
Did it?
But they didn't ratify it. So this is a small, it's a small ICC geek for geeks.
Yeah.
And I'll explain. The Rome Statute is an international treaty signed by 125 states so far, if I'm not mistaken. So more than half of the countries in the world are members in the Rome Statute. The Rome Statute establishes an international court, permanent court, the ICC, the International Court of Criminal Court, which has the jurisdiction to put to trial individuals who are responsible for international crimes. War crimes, crimes against humanity, crimes of aggression, which are use of force illegally. Once in the Nuremberg trial, they were called crimes against the peace, and genocide, which is the kind of crimes. So these four categories of international crimes, the ICC has the jurisdiction, has the power to try those individuals who are responsible for committing those crimes, because states do not commit crimes. People, human beings commit crimes. States may be responsible for crimes, may be under an obligation to pay compensation, but those who are criminally responsible are the leaders, the generals, the soldiers, and so on. So the International Criminal Court is a court that tries international offenders. Israel and the United States have signed the Rome Statute, but in order for a treaty to bind a member state, it's not enough that they sign it; they have to what is called ratify it. It's a second phase. The United States signed their own statute on the last day that Bill Clinton was president of the United States. On the same day, Israel also signed it. And then when George Bush became president, one of the first things he has done was to revoke the signature and say we will never join the ICC. And immediately Israel has done the same. So Israel is not a member of the ICC, nor is the United States, but the jurisdiction of the ICC is not can deal with Israelis when they are suspected of committing crimes on territory of a member state. So if an Israeli commits a crime in Germany, okay, which is a member of the ICC, then the ICC has jurisdiction over that individual, although Israel is not a member. And what we're seeing now is that Palestine, the state of Palestine, has signed and ratified their own statute. So ICC has jurisdiction over crimes committed by Palestinians or in Palestine, even if it is committed by people who are not Palestinians. That's why we do have an investigation into alleged crimes by Israelis. And there are also 2 arrest warrants, as I'm sure you know, against the Israeli prime minister and against the former defense minister.
Is there a constitution in Israel?
Is there a constitution? Well, Israel doesn't have a full constitution. In our Declaration of Independence, it was promised that a constitutional assembly will be convened in order to adopt a constitution. It didn't happen for many reasons. It didn't happen. And instead, the Israeli legislator, the Knesset, the Israeli parliament, has enacted throughout the years several pieces of legislation that are titled basic laws. And these the idea that was adopted when it was clear that a full constitution cannot be signed because there are too many disagreements between different sectors of the Israeli society on how what this constitution should include. Instead, it was decided that the Israeli constitution will be legislated in chapters. So every few years, a different basic law is legislated and becomes part of this very, very partial constitution. So we do have a very partial constitution in the sense that we have norms that are higher than regular laws.
Can you explain the difference between civil and national rights? And do they differ from Jewish and non-Jewish Israelis? And if they do, how?
So first of all, in the human rights philosophy, usually it is accepted to divide human rights into 3 types. I mean, there are all kinds of categorization of human rights, but it is very customary to talk about 3 types of rights: civil and political rights. Then you have economic, social, and cultural rights, which are the red rights. And then you have collective rights, group rights. For example, the right of self-determination of peoples, which is enshrined both in the International Convention on Civil and Political Rights and in the International Convention on Economic, Social, and Cultural Rights. So both major instruments of international human rights law, both of them, including the first paragraph, the first article, the recognition of the rights of people to self-determination, meaning that nations have a right to have their own political structure, their own political independence, basically the right to have a state. And that right is basically what underlines the post-colonial era, the idea of decolonization, that the major powers of the Western world that dominated and colonized the other parts of the world for 400 years have to allow the peoples, the nations under their rule to have their own independence. And indeed, in the 50s and 60s, many new countries were born out of the idea that there is a right to self-determination. Israel, some would see it as a continuation of the colonial world, where Europeans have immigrated into third world or developing world area, in this case in the Middle East, and created and ethnically cleansed those who are there, and created their own country, because Zionism was based in the beginning on European Jews who fled Europe to the land of Israel and established their own country. The Zionists would tell you absolutely the opposite. This is decolonization. This is exactly the idea of a new country that was born out of the right to self-determination of the Jewish people. That's why it's a homeland of the Jewish people. And so when we're looking at the state of Israel and how it is defined today as the homeland of the Jewish people, yes, it is a inherently discriminatory system when it comes to collective rights. When it comes to collective rights, only Jews have a right in Israel to profess, to implement their right to self-determination. The Palestinian minority of citizens within Israel, they don't have that right, and Israel does not recognize that right. In fact, it outspokenly rejects the idea that they have collective rights, such rights as to have their own language being developed and used, and cultural rights, etc., which is an immense problem. And also, only Jewish people from around the world can come to Israel and immediately get citizenship. This is the right of return. And that's also a very discriminatory legal situation where my family members who live in the United Kingdom, I have 2 aunts and family and cousins, they can come any day and become immediately citizens of the state of Israel, while my neighbor, who is a Palestinian, and he's also a citizen of the state of Israel, his family members who live abroad, they don't have that right.
Could you tell us what the judicial reform attempt was about, and what were the reactions of Israeli civil society, and is it still pursued today?
The judicial overhaul, which sometimes also is called the constitutional coup, is an attempt by the current government to consolidate almost all power, all public power within the executive. So ruin the separation of powers and weaken extremely all gatekeepers, the judiciary first and foremost, to take away the judiciary's power, for example, to revoke laws enacted by the parliament when they are in contradiction with basic laws, which we talked about before. When you have a constitutional democracy, that means that the legislator is restricted. The legislator cannot legislate whatever it wants. It has to adhere to the basic laws, to the constitution. And who decides whether a certain piece of legislation violates the constitution? For example, let's assume that the legislator legislates a law which precludes people precludes women from being from getting certain privilege in public spaces. Okay, they're not allowed to enter certain spaces that are only for men. Now, the legislator had a majority that voted for it, but it might violate the rule or the norm in the constitution, which says that the legislator should not legislate discriminatory laws. Now, who will make that decision? That's for the courts. That's for the judiciary. And the judicial overhaul is about stripping the judiciary of its powers to intervene both in acts of legislation and in acts of government, and revoke acts of government. In practice, what they want is to have a democracy that is only based on the rule of the majority. Whatever the majority decides, that rhymes. And that's, of course, a technical democracy. It's not really a democracy. And the Israeli public has stormed out to the streets by its hundreds of thousands and even millions, went out of the streets to protest against this, the judicial overhaul that is made of many, many pieces of legislation. And for months and months, on a daily basis and definitely weekly basis, hundreds of thousands of people were out in the streets protesting against it. And it is still, and then October 7th happened, which both stopped the advancement for a while of the judicial overhaul, but also stopped the demonstrations. And now the judicial overhaul is back full steam, and this government is now again trying to create this authoritarian regime where only the prime minister and his cabinet decide everything, and no one can review their deeds.
What does international law say about occupation? Can it be legal under certain circumstances? And what can occupying powers legally do and what can't?
Okay, this is a question that the answer to which is a full year seminar in the university. However, I'll try to answer it in 3 minutes, and I'll start with the prohibition that I mentioned on the use of force in international relations. You remember that I said this is probably the most important development or change in the international law in modern times. And it's important because, first of all, it's a big change, and second, because what's behind it is a very noble and extremely important interest, the pursuit of eradication of wars. Humanity has told itself what grown-ups usually tell only children: don't use your hands, talk to each other, right? That's what they did by outlawing wars or use of force. It's not enough just to say that use of force is illegal. You need to cement this prohibition with more doctrines, more legal doctrines, in order to make it unworthwhile for leaders to go on wars of conquest. And so the most important prohibition in international law that cements this idea of illegality of use of force is the idea that you cannot acquire sovereignty by force. You cannot get more lands by force. Okay? If there is a war, and let's assume that the war is legal, it's a war of self-defense, and in that war, your army finds itself in effective control over territory that is beyond the borders of your state, then it is in a state of occupation. International law does not outlaw occupation. It does not outlaw occupation. Occupation is a legal status, but it regulates it so that it will not become sovereignty. So it will not be annexed. And the idea is that occupiers should not benefit from their advantage in force. Because if you allow aggressors to occupy a land and then make it part of your own land, then you incentivize wars. And the whole field of international law that deals with laws of occupation, which deals with occupied territory, is about maintaining a temporary administration in that occupied territory, which is not sovereignty. So it is not illegal to occupy land, but the occupier is not a sovereign. It means that the occupier is a temporary administrator. And international law provides that the occupier, meaning the commander of the army of occupation, has now all the powers of all three branches of government. The military commander is the executive, is the judiciary, and it can set up military courts, and the legislature. So orders by the military commander are like primary legislation. But it is not a sovereign. The only things that he or she can do, the military commander, is to maintain the situation in the occupied territory as the way they found it, and to protect the rights of those who are under occupation until the occupation is over in an agreement. Eventually, the occupation must end in an agreement between the parties. And until that agreement is achieved and a permanent status for the occupied territory is decided, until that moment, the occupier must protect the rights of the occupied and protect security. It cannot exploit the occupied territory for its own, economic or political interests. I hope this is, as I said, I teach laws of occupation. It's a full year course, so it's difficult to answer in 2 minutes.
Indeed. You previously compared basic rights between Israeli and Palestinians, giving your example of your neighbor. Could you specify what the most basic rights Palestinians are supposed to have under this framework?
Well, we need to make a distinction between Palestinians who are citizens of the State of Israel. 20% of the Israeli society are Palestinians. They are not under occupation. They are citizens of the State of Israel, and they live in the borders of Israel as they were set after the War of Independence in 1949. There are about 2 million Palestinians who are citizens of Israel. That's one group. There's a different group, and that is the group of Palestinians under Israeli occupation in the West Bank, in East Jerusalem, and in Gaza, in the Gaza Strip. There are millions of Palestinians. They are not citizens of Israel. They do not enjoy any of the rights that citizens of Israel enjoy. So if we're talking about the first group, as I said, almost by definition, are less citizens than I am because they're not Jews. And as I said, Jews have a priority in the sense of collective rights. And when it comes to collective rights, this country, its official language is Hebrew. Its holidays are Jewish holidays. The resting official day is Sabbath, Saturday, not Friday, which is the sacred day for Muslims, not Sunday, which is the sacred day for Christians, and we have both Christians and Muslim and Palestinians. So if you inspect Israeli law book, you will find that Palestinians, black letter law-wise, they have all the rights that Jewish Israelis have, except the group rights. Okay? But that doesn't tell you the full story, because when it comes to policy and practice, there are many policies in place, enormous amount of policies that the governments of Israel, since its creation, since its establishment in 1948 and until today, have put into place, which severely discriminates the Arab minority, the Palestinian minority. So, I want to introduce you to a concept. I don't know if you heard that concept, which is ethnocracy. Ethnocracy describes a system of government where you have several ethnicities or nationalities in one state, all are citizens, seemingly democratic, but in fact, one ethnicity or one group is superior and holds the centers of power, the political, the economic, the cultural centers of power. And that's the situation in Israel.
Which rights do settlers enjoy in the occupied Palestinian territories by comparison?
So when we discuss now the disparity or the difference between Jewish Israelis and Palestinians who are citizens of Israel, we saw that there's no equality. I mean, there's a gap between the rights of those and those. But when we go beyond the Green Line into the West Bank and East Jerusalem, that's where the disparity grows to a huge massive size. Because unlike the Palestinians who are citizens of Israel, the Palestinians under occupation, they are not citizens of any country. They are stateless. They are residents of the West Bank or East Jerusalem, but they do not enjoy any civil and political rights. Under international law of occupation, their civil and political rights are suspended for the duration of the occupation. So they can't vote. They are not allowed to be elected. They do not have any involvement, any influence over the mechanisms that govern their lives, that decide on the norms, the laws that govern their lives. And their neighbors, the Israeli settlers, enjoy all the civil and political rights. They have full political power, and they have complete the networking and all that is needed. Now, when you have this imbalance, it's almost a physical force that diverts all the resources. You can see it in your own cities and towns. When you have neighborhoods that are strong and rich, of people who are from the higher classes, and you have neighborhoods that are torn and working class with immigrants, you see how the city council usually provides more services to the more rich neighborhoods. So this is almost a force of nature, that those who have rights, those who have connections, those who have power, political power, they always enjoy more services. And when it comes to settlers and people under occupation, this phenomena becomes wild. So I'll give you an example. 99.76% of all the public lands in the West Bank that were ever allocated to anyone by Israel were allocated to Israeli settlers. And only less than 0.25% were allocated to Palestinians. Most of that 0.25% was allocated for the use of Palestinians who were forcibly transferred from where they lived in order to allow the expansion of a nearby settlement. And that's just to show you how the settlers enjoy superiority and the Palestinians are inferior. That is why, and I'll end with that is why international law of occupation prohibits, with no exception, the creation of settlements, the immigration of citizens of the occupying power to the occupied territory. Exactly because that kind of demographic engineering creates immediately a diversion of all the resources from the occupied people to the settlers.
Speaking of allocated land, back in 2005, Israel withdrew all settlements from Gaza. So why was Gaza still considered occupied territory for the United Nations and most international legal scholars?
Occupation is not supposed to be with settlements at all. I mean, it's a aberration that we have an occupation with settlements. Settlements are not supposed to be part of an occupation. They are illegal, and so many occupations are with no settlements. The question of whether a territory is under occupation or not has nothing to do with the question of whether there is colonization of the territory. The test for occupation is whether the occupier has effective control over that territory. And when Israel pulled out of Gaza, it didn't really pull out of Gaza. It ended its permanent land presence in Gaza. Only that. We have continued to control the strip from 3 borders, the maritime border and 2 land borders. We had a huge influence and control over the Egyptian border because we have agreements with Egypt that allows us to make decisions over who crosses from there and who does not. We had complete control over the airspace of Gaza. We had control over the flow of water and electricity to Gaza. We had control over what goods flow into or out of Gaza, and when people are allowed to go out and in. And let me tell you another thing. We had control over the population registry in Gaza. I usually tell those who I give lectures about Gaza to that no person was allowed to be born or to die in Gaza without the permission of the State of Israel. In the sense that when someone was born, the world does not recognize that individual until he is registered with the Israeli-dominated population registry. So Israel had effective control over many, many dimensions of the life in Gaza, to a degree that most legal scholars said that Gaza is still under occupation. Because that control yields responsibility. That control creates obligations on the part of the person, of the party that controls the territory.
Oh, right. Well, in 2024, the ICJ issued an advisory opinion on the legal consequences of the occupation. Can you walk us through it? What does it say, and what are the consequences for the international community?
So the ICJ advisory opinion is a dramatic one, because what it concluded is that Israel uses the powers that international law of occupation provides it. As I said, international law does not outlaw occupation. It says it actually provides powers to the occupier to administer temporarily the territory. So the ICJ reached the conclusion, the very sad conclusion, that Israel has abused the powers that it was given to administer the occupied territory in order to frustrate the very fundamental interests that underlie the laws of occupation. First and foremost, by embarking on a colonization, huge, massive project. 700,000 Israelis have been transferred to the occupied territory, changing the demographic nature of the occupied territory, pillaging all the resources of the territory, and transferring them from its indigenous Palestinian population to the settlers. So the ICJ has made a ruling or an assertion that the occupation has become illegal, unlawful, because Israel violates the laws of occupation in a fundamental way. And so while when it started, it was not illegal, as I told you, occupations are not illegal. Throughout the years, Israel has begun a process of annexation, of imposing its sovereignty over the occupied territory, and thus the occupation became unlawful. And Israel's presence in the occupied Palestinian territory, meaning the West Bank, East Jerusalem, and the Gaza Strip, is unlawful and must end immediately. And so it went on the court to say that the international community, all states, must reconsider their relationships and links to Israel and make sure that no dealings they have with Israel contributes, even indirectly, to the Israeli unlawful presence in the West Bank and in Gaza and in East Jerusalem. The court went on to say one more damning thing, very shameful thing, that the dual legal system that was created in the West Bank, in which Israelis enjoy one set of laws, Jewish Israelis, and the Palestinians, completely different, very draconian laws. The disparity in allocation of resources, the key feature of the regime of occupation, which is Jewish superiority and Palestinian inferiority, all of this leads to a very sad conclusion that Israel is engaging in racial segregation and maybe even in the crime of apartheid. So all of this was what the International Court of Justice has concluded.
The Trump administration sanctioned the ICC. What exactly does that mean, and how does that affect the court authority?
The Trump administration and the Israeli government are both presenting a massive challenge which was never in place before to the whole system of the rule-based order that was put in place after the Second World War that we talked about. The sanctions on the ICC judges and prosecutor are a signal to the international community that the rule of law is not equal. That when the ICC charges African warlords or President Putin, who both are not allies of the West, then it's fine, and it will be supported and applauded by the West. And when it targets America or its allies, specifically Israel, then the court will be attacked and maybe even collapsed. A rule of law that is only for some is not a rule of law. And I have to say, I'm speaking to German high school students. Germany is blamed, is guilty for the same thing, not as severe as Trump's actions, because you have not placed any sanctions against the court. But you should do the drill and find the statement issued by the Justice Ministry, your Justice Ministry, after the arrest warrants were issued against Vladimir Putin, and the statement issued after arrest warrants were issued against Benjamin Netanyahu. The idea that your counselor said that he would invite Prime Minister Netanyahu to Germany is an affront to the rule-based order. It is undermining the whole system that was put in place in order to prevent mass atrocities. It's not a small thing. It's mass atrocities we're talking about. And the ICC's arrest warrants against Netanyahu allege that he's responsible for the crime against humanity of extermination. Extermination is mass killing. And for the war crime of starvation as a method of war. It's no small thing. It's not misdemeanors. It's the atrocities that we as a human race promised in 1945 never again. So the sanctions is a beginning of a very big challenge to everything that we have worked for since 1945.
Let's go from law to life. Can you share a couple of stories that paint a picture of the reality in the West Bank and how has the situation changed since October 7th?
The situation changed dramatically because all eyes are on Gaza, understandably. But while the limelight is on Gaza, the West Bank is going through its own ethnic cleansing. Sorry to say that. I'm an Israeli, I'm a Jew, and this is very embarrassing for me to say. But Israeli settlers, together with the aid of Israeli soldiers, have been embarking and committing raids on small Palestinian communities in the less populated areas of the West Bank. For those of you who know the geography of the West Bank, so the Jordan Valley and the South Mount Hebron and the Jerusalem periphery, these are all desert areas where small, very small traditional communities of herders and farmers live. And about 60 different communities were displaced since October 7th. 60 were displaced, all through violence that had absolutely no police force or anything that would stop it. The army has created roadblocks immediately after October 7th all around the West Bank, denying access to Palestinians to their farmlands, to their groves, to their which is their livelihood. And some of them were not able to tend to their fields for more than almost 2 years now. So the Palestinian community is being pushed from into their urban enclaves, where the density is terrible. And also, the army has embarked on several military operations in the refugee camps, refugees from 1948, those who lived where now Israel is and had to flee or were deported to the West Bank, and they live, their children and grandchildren and great-grandchildren live in refugee camps. And the refugee camps are, of course, a hub for radicalization. And the Israeli army had embarked on operations, military operations, with a huge force, killing hundreds and displacing tens of thousands. So the situation in the West Bank is very dire.
What was your biggest win in law?
My biggest win?
Yeah.
I had many victories. But I think I had many victories. I make a distinction between victory and success. Victory is when you get the remedy you ask, an injunction, a court order that prevents the government from doing something or demands that the government will do something, right? That's a victory. But success is a more nuanced phenomena. It asks the question, in the long run, what is the impact of the court ruling? Because sometimes there are backlashes. You win, but then there's a backlash. The government changes the law because they didn't like, or the opposite. Sometimes you lose, and that creates such a stir that in the long run, that loss became a success. So a victory can become a failure, and a defeat might become a success. But my biggest victories are in the cases that involve illegal construction by settlers on private Palestinian land. And I've been involved in several litigations where the court has issued an order that coerced the state to demolish those structures and remove the settler communities from the land of my clients, restoring the land to my clients. So that's one type of cases where I won 4 or 5 of those. And then there is another type, and that is, it has to do with the separation barrier, the separation fence or wall that Israel built and took a lot of land from the Palestinians. And in 3 different cases, I won a court ruling that coerced the government and the army to change the route of the wall so that my clients' lands would be restored to them.
After seeing everything that's happened, would you say that international law is still relevant, and can it still serve justice?
It's the most important tool that we have. It's the standard that the only standard that we all, international civil society, we all have one standard to look at, and that's international law. So I think international law is still important. It is under huge challenge. And we as citizens of the world need to strengthen it. I remind you all, and maybe that's where we'll end with some optimistic note, that if it was up to the leaders, if it was up to governments, no sanctions would be imposed on apartheid South Africa, because there were a lot of interests in maintaining good relations with South Africa as a country that opposes communism, for example. It was the international civil society that went out to the street and created the movement against apartheid that coerced the governments to take action against South Africa. If it was not the international civil society, we wouldn't have any action taken against climate change. It's only thanks to international civil society. If not for international civil society, there was no disarmament of nuclear weapons. Yes, none of them is perfect. We have a lot to achieve more. But if not for us, nothing would have happened. And the same when it comes to Israel-Palestine and to international law in general.
If you could rewrite only one law, Israeli, international, or moral, what would it be?
I don't know. I thought about it. I think one of the problems, it's not a moral issue, but it's a technical issue, but I think it is extremely important. I don't think we should have 5 states that have veto power in the Security Council, because that blocks the international community from doing the right thing. It's Russia that blocked action against the Syrian leader that attacked his own people with chemical weapons. It's China that blocked, it's Russia that is a member, the permanent member that precludes the international community from doing something against its own aggression against the Ukraine. It's the United Nations that constantly blocks any action taken against Israel for its violations of international law. I think one thing that we need to change is to change this system that gives 5 states, and in fact 3, because France and the UK hardly use their veto power. But Russia, China, and the United States more than anyone else do. And I think that's wrong. It's not a big moral issue, but it's something that might change the international ability to take on atrocities.
With that being said, we've reached the end of our podcast. I'd like to thank you very much to have talked with us today, to have given us your time. It was a great privilege talking to you, Michael Sfard.
Thank you, Ben.
It was a privilege talking to you too. Thank you very much.
Thank you for your time. Thank you for listening. If this conversation was meaningful or unsettling, if it left you with answers or more questions, feel free to like, share, and subscribe. See you next time on our Israel-Palestine podcast.